Lesson 1. Dialogue. Hello, sir. Can I come in? Yes, please. By all means do. Have a seat. You're one of my students, right? Yes, that's right. My name is John Silver. I'm a first-year student at the law faculty here at the University of Warsaw. Can I talk to you for a minute or two? You promised to explain the doctrine of judicial precedent to me. I'm involved in a project aimed at popularizing legal knowledge in secondary schools and among the non-legal population. It's an assignment I volunteered for. I need someone who could give me an interesting overview of the concept and be able to illustrate the key points with examples. Yes, of course. Are you sitting comfortably? Are you ready? Okay, let's get started. Broadly speaking, the doctrine of precedent is a concept, a principle, which says that like cases should be judged alike. I'm not sure I understand correctly. Could you give me some more details on what you mean? Well, the doctrine of judicial precedent is based on stare decisis, which is Latin for to stand by the decision made. Once a point of law has been decided in a particular case, that law must be applied in all future cases which contain the same material facts. A judge hearing a decision thinks, there is a similar or identical case from the past. Let's look at that decision from the past then. Why reinvent the wheel? In fact, if there is a precedent for this case, he is obliged to consider it. If the precedent is applicable, he is bound by it. We lawyers say that the precedent is binding on the judge. So in a way, the case has already been decided by another judge. Yes, kind of. We are just going to apply the reasoning of the judge in that previous case to the current case, the case at issue, the reasons and rules of law he used. How do we know which past precedents to look at? The judge and lawyers involved consider all precedents which might be relevant to the case in point. Cases and precedents which are merely similar, that is, where the facts are similar to the facts of the case under consideration, are not binding. The judge is not bound by the precedent. He does not have to follow it. But where a past case has a set of identical facts, he has to apply this case's precedent to his case. But how do we determine which facts are identical and which ones are only similar, sir? This is something that lawyers in court argue about all the time. A party tries to persuade the court that the past cases cited by them, which are favourable to their side, have identical sets of facts and should be applied. The other party's lawyer tries to do the opposite. That is, to demonstrate that the cases that they have cited are relevant and should be applied to the present case. For instance, in 1928, the House of Lords held that a manufacturer had a duty of care to make sure that their product was safe for human consumption, safe for consumers. This duty extends to every potential consumer of their product. If the product is unsafe and has caused harm to the consumer, the producer is liable. They will suffer the consequences and will have to compensate the injured party, the consumer. The consumer has a right to claim damages from the manufacturer. So, for example, if a judge nowadays is hearing a case where a child has swallowed a piece of a toy which was supposed to be solid and disintegration-free, the producer of the toy will be held liable because they owed a duty of care to consumers. This is the general rule established in the 1928 case. That's unless they prove that the disintegration of the toy was not their fault, and all reasonable measures had been taken to make sure the toy was solid and safe for kids of that age. Here, the judge would be using a precedent, a rule established in a previous case, whereby a producer owes a certain standard of duty of care to consumers. But I always hear the following phrases a lot: the hierarchy of the courts, material facts, binding precedent and persuasive precedent and rules of law when someone is talking about precedent. Could you give me some more details about what these all mean?